For many of our clients, this is the first time that they're going through the criminal justice system. And with that, there can be a lot of anxiety, there can be a lot of concern about what to expect. They aren't sure what this process is going to look like for them. Today I'm going to go over the 10 stages of a criminal case as I like to think of them. I'm Paul Ghanouni, founder and managing attorney at the Teen and Young Adult Defense Firm, where we focus on helping teens and young adults protect their future when they get in trouble with the law. Our firm primarily focuses on helping people who are in their mid-20s and younger. Now understand that I'm going over the 10 stages of a criminal and juvenile case, and these stages may not apply in every case, they may not apply to your case, but this is a big picture overview for you. I want you to have an overall understanding of what the process can look like, but if you need specific help for your case, please contact our office for specific legal advice for your case. So the investigative phase is the first phase that we're dealing with here. Understand that as soon as this investigative phase begins, that's when law enforcement, prosecutors, and their investigators start working on their case against you. The investigative phase may take 10 to 15 minutes on the side of the road in the case of a traffic stop, or it could be something that takes much longer if it's a much more complex type of case. The next stage are the charges. Now, the charges can be something as simple as law enforcement writing a ticket on the scene in the case of a traffic or certain misdemeanor cases. It can also be something that law enforcement goes and gets a warrant for an individual's arrest and begins the charging process that way. Now, the next stage we look at it is the arrest, and not every case has the arrest. In some cases, the arrest actually comes before the initial charges. The charges and the arrest often happen at or around the same time. If somebody's arrested and they can't bond out of jail, then the next place that they go is the first appearance hearing. First appearance hearing is a hearing that takes place when somebody's been arrested and they can't afford bond or they don't have a bond. And that hearing takes place within 72 hours of the person being charged and arrested. The judge at that hearing will make an initial determination of bond, if that judge can set bond, how much the bond should be, what types of conditions of bond to put in place. And that is a fundamental point that an attorney can be involved to help make sure that, or attempt to get the bond to an amount that the person can post to be able to get out of jail, and that the conditions or the types of conditions that the person can live with and be able to continue to live their lives. After somebody is out of jail, or if they never went to jail, the next stage that takes place is the formal charges. Now you may be thinking, well, I thought there were charges that took place in step 2. There were charges that took place in step 2. Those charges were brought about by the law enforcement officer. The formal charges in step 5 are brought about by the prosecutor's office. Now, a prosecutor's office reviews evidence, incident reports, charges brought by the officer, and they can charge somebody with the same things that the officer charged them with, or they can add charges, take away charges, change charges. So sometimes we see people who are confused because they don't understand why the charges that they were charged with when they were originally arrested or given a ticket are different from the ones when they went to court, or they have more charges when they went to court. The next stage that comes in after the formal charges is the arraignment. Now, the arraignment is when you are formally told what all the charges are in court. And now this is a fundamental date because you have 10 days from the date of your arraignment to file motions to either challenge evidence or to challenge the charging document or other types of motions. So it's really important to have an attorney at the arraignment during this process. We've seen people who thought, well, I'll go to the arraignment, I'll see what's going to happen with my case, and then I'll make a decision about whether or not to get an attorney. And some of those people miss some very important deadlines that take place at that arraignment. Next, we talked about the formal exchange of evidence. That's the next stage in the process. Now, the formal exchange of evidence, I say it that way because there are motions that get filed to get evidence from the prosecutor's office, certain things that we're required to provide the prosecutor's office. And we can be doing an investigation throughout this entire process, getting other records, interviewing witnesses, trying to find other information that can be beneficial. But the formal exchange of evidence takes place typically after arraignment. The next stage that you'll see in some cases, and stages 8 and 9 as I've put them on here, depending on the court, can be flipped. Some courts you'll have your calendar calls first and then your pretrial motions. Some courts you'll have your pretrial motions and then your calendar calls. But the fundamental thing to understand here is that the calendar call is going to be an announcement of whether your case is ready for trial or not. And that's often the next stage that people end up seeing in a criminal case, is showing up for a calendar call, having to announce whether their case is ready for trial or not, and then being prepared to go forward with a trial at a future date if their case is ready for trial. The pretrial motions are motions that will take place to challenge evidence, challenge the admissibility of statements, challenge law enforcement's conduct, those types of things. When you hear about people saying evidence got thrown out, that's usually through pretrial motions. The next stage that you'll typically see in a criminal or a juvenile case is the trial. And that's going in front of a judge or a jury, depending on the type of case and the court that it's in, for them to determine whether somebody is guilty or innocent of the charges. Now, not every case has to get through all of these stages. At any point during this entire process, negotiations can take place, information can be presented to prosecutors, the case could be dismissed either by agreement, through negotiations, through the exclusion of evidence, but this is the overall process that you're dealing with. And the earlier that a criminal defense attorney can get involved in this process, the higher the likelihood is of having a more quality investigation, to look at options to try to get the case resolved favorably, to try to help you through the process. And so we always recommend getting a criminal defense attorney involved as early in this process as possible, so that you have everything that you need, all of your rights are protected, and we have the highest chances of getting the best outcome for your case. Starting up here is when law enforcement, prosecutors, and their investigators start preparing their case against you. So if you wait until here to get an attorney, or even until here to get an attorney, you're already behind the 8 ball. And we want to make sure that you have every opportunity for your future. If you're dealing with a criminal case and you need help with that case, regardless of whether you think you're being investigated, whether you've already been arrested or charged otherwise, or whether you've already gone to court, we're here to help. We can help you get an understanding of what your options are, what the potential outcomes could be. Please contact our office to have a complimentary defense strategy meeting to go over where you are in your case, what options make sense for you, and to see if it makes sense for our team to help you.